Hi there, my name is Eliza Kelly and I will be doing this week's tutorial on native title and WIC. Before we begin, I've just got a quote up on the screen which I think is quite pertinent to this topic. The very ink with which all history is written is merely fluid prejudice. The very ink with which all history is written is merely fluid prejudice. Now this quote from Mark Twain hits what is really only the surface of an ongoing battle in broader history, but also in regards to Indigenous Australians and the conflict that has happened over the last 200 years from European settlement. And I think it's important for us to remember before we even broach this topic that history has for such a long time been written, conveyed with prejudice, with one side of the story, with the superior side of the story. The more powerful society has dominated that field. And so for a long time, we weren't able to hear from minority groups. And I think it's a really important topic that we're addressing today as we look at native title and WIC and what that looks like as Indigenous Australians started to gain some of the rights and be able to retell and rewrite history in perhaps a more pertinent and more equitable manner. So the first thing we should always discuss and broach is an understanding of terra nullius when looking at Indigenous land rights. Now terra nullius is from the Latin. It is a physical translation to nobody's land. Often in Australian history we regard it as land belonging to no one. Now, a principle under the European settlement was that when Captain Cook arrived, he declared Australia terra nullius, as land belonging to no one, because it did not have an establishment of society or culture or cultivation of the land that under European terms determined that it was owned by a certain group. Now this really does highlight in essence the ignorance of what white superiority and singularity was like during the colonial era of the 20th century and back to those roots of the 18th century. It's really highlighted well in this quote from Auntie Beryl Timbury Bella. She says, "They were so ignorant, they thought there was only one race on the earth, and that was the white race. So when Captain Cook first came, when Lieutenant James Cook first set foot on Mongol land over at Kundal, which is now called Kurnell, he said, 'Oh, let's put a flag up somewhere, because these people are illiterate. They've got no fences.' They didn't understand that we didn't need fences, that we stayed here for 6 to 8 weeks, then moved somewhere else where there was plenty of tucker and bush medicine, and we kept moving and then come back in 12 months' time when the food was all refreshed." Now this highlights a particular dilemma that has surfaced in more recent histories regarding Australian settlement. So terra nullius did declare in its European sense that the land did not belong to anyone. However, the Indigenous Australians did not see it this way. Aboriginal and Torres Strait Islander people have been here for thousands of years. And so for them, the land is not to belong to anyone. And this is the dilemma that arises and we'll see to continue to arise throughout the concept of native title rights, is that the land does not necessarily follow a sense of ownership, but rather, as we'll begin to see, the Indigenous Australians saw themselves as custodians of the land. So what was the importance of the land? If we look at a cultural and spiritual perspective, the dreaming, which was the Aboriginal spiritual belief system, the land and identity are all interconnected and interrelated. I love this concept that we begin to see the beauty of the Aboriginal spiritual beliefs, that there was no difference, there was no ownership, there was no separation, but part of this wholesome belief system that the dreaming and the land and their identity was all interconnected. They gained a sense of worth and sense of purpose from looking after and cultivating the land, and they gained their identity and their ancestry through it as well. So we know the land is of extreme significance. It's a place where they're practicing ancestral customs and laws. It's a place of their heritage, and it's a place where they pass down their oral histories as well. So like I've said, Aboriginal and Torres Strait Island peoples are custodians of the land. They don't see the land as something that should be owned or belonging to anyone. So the problem was, Europeans did settle in Australia. They followed a track of terra nullius and assumed that the land was there for their own use and for their own establishment of a white society. So what were the consequences of this? We know throughout Australian history the various policies that were put into place to try and manage, at times cooperate naively and ignorantly, not actually taking into consideration the rights and the wishes of Aboriginal and Torres Strait Islanders, that it didn't work smoothly and that we did hurt and do wrong by the Aboriginal and Torres Strait Islander peoples. So what does this look like in the present Australian legal climate? We get to the 1960s and we start to see a land rights movement start to develop for Aboriginal and Torres Strait Islanders. However, it's not until around the 1990s that we begin to see formalisation of this process. So I have got a definition here. The land rights movement is a religious and political movement to secure the rights of Aboriginal people to their land and ensure their religious, spiritual and cultural integrity is preserved. And this is all, again, inherently connected to the dreaming. However, we look at native title and we move into the 1990s, and this is where we have our first big formal legal native title claim under Mabo in 1992. And it's not our first big one, but our first big successful one. And so in 1992, Eddie Mabo, as a part of the Murray Islands, claims that his people had a right to that land that the Australians had taken away from them. Now this was the first successful Indigenous native title claim, and it incurred a lot of understanding and call for law reform as to what native title rights looked like, how they could be established and what they were organised under. And so as a result, we had the Native Title Act of 1993. Now this act outlined a number of main points. Firstly, it was there to provide recognition and protection of native title, that it was an actual right, that there was a recognition and insistence that this was a thing. It also was there to establish any future dealings with native title in the legal system. So we do know we have common law, the case-built law that would have stemmed from Mabo. They felt as though statute law, so our formal legislation, also needed to provide a platform for these claims. Under that, they were determining what was a native title claim, what were the implications of that, and then also perhaps re-looking at some of the other native title claims that had gone through the court system and how they would fit into this jurisdiction. So it was a very significant time in the early 1990s for native title and the land rights movement. However, was this a naive period of peace? And I think this is an important thing to think about. The implications of native title for the rest of Australia were not at first understood or recognised post-Mabo. Rather, we began to just be in this sort of honeymoon phase of the prosperity of having native title rights for Indigenous Australians. However, there are a number of questions that arose from this. Obviously, the Murray Islands are an extended part of Australia, so what did native title look like on the Australian mainland? Could native title exist on the Australian native title on the Australian mainland? Could native title exist on the Australian mainland? Did it grant the relinquishment of rights that pastoral carers and tenants had of land? What about mining leases? Would compensation be payable to any native title, land and water owners? What rights did these native title holders have? All of these questions began to surface following the Mabo case and the implementation of the NTA in 1993. As a result, what came about was this need and recognition that we needed more clear and precise legal rulings, and this came through the Wick case, the Wick Peoples versus the State of Queensland and Oz in 1996.